There is a new elephant in the room. The emergence of DeepSeek has caused a huge financial shock as well as a bit of a legal disruption. It is thought that DeepSeek has been engaged in the practice of distillation, and it used the output of OpenAI's ChatGPT to train its own large language models. In this video, I'll be talking about the practice of distillation, whether OpenAI holds copyright to its output, and whether distillation is a legally acceptable technique. Say you decided to train a large language model like OpenAI's ChatGPT. In order to do that, you require a large amount of data. We are talking about hundreds of gigabytes. And if you want to gather this data, you have to go to the web and scrape the publicly available data. This is called data mining, and can be done with special programs called web robots and crawlers. For your information, ChatGPT is trained on 570 gigabytes of data. Now, web data mining is pretty widespread practice in the United States, but the problem is that it is in a legally gray area. So you might do the data scraping and it will be permissive under the US law. The point is that if you scrape the private information or the copyrighted work, you might be violating the US law. But the point is that the enforcement of copyright depends on the copyright holder, who might decide not to pursue the court proceedings because this might take a long time and can be costly. Therefore, what the copyright holder does, the copyright holder abstains from going to the court, and in that way web data mining will go unnoticed. But if it is noticed and the case goes to the court, under the US law there is no established practice. Therefore, it can be a problem to make the web mining practitioner responsible for the infringement, as the court should decide the case on its merits, and as I have said, there is no direct established practice. Now, when it comes to the EU law, the situation is a bit different. Under the EU law, it is possible to engage into web data mining and even scrape copyrighted works, and you will be fully compliant. Just the problem that might arise here is that the copyright holder may place an opt-out, that is to say a preservation of the IP rights, which will be manifested in a written notice, and this notice will say, okay, don't do web data scraping. If you do that, you will be held responsible. And that is all. And if you do the data scraping of the copyrighted work and there is an opt-out notice, then you will need the authorization. Many authors relinquish their copyright and place their works in a public domain, but others behave on the contrary. You may find, read, and download the works authored by George R.R. Martin or the New York Times articles, and you can do it without a payment. But the point is that you will be engaging in the unauthorized use. In order to be fully on the right side of the law, what you need to do, you need to make a single payment on a legitimate platform for a book, if you want to purchase a book, or you can become a subscriber. It is probably a safe move not to include any copyrighted data in the AI training material, but this might pose certain challenges. It is possible that the data you have is of insufficient or of low quality. OpenAI clearly states that it uses publicly available internet resources to train its own ChatGPT model, and OpenAI doesn't expressly exclude the copyrighted works in any statement. In 2023, the New York Times sued OpenAI and Microsoft for large-scale commercial use of its content, saying that OpenAI ChatGPT models were trained on its content, and this constitutes the copyright infringement. Also, the New York Times experimented with ChatGPT 4 and found out that ChatGPT 4 could actually cite the New York Times content. It could summarize New York Times articles, and what's more, it could write in the New York Times' expressive style. There is another interesting complaint which is filed by the group of authors, among them George R.R. Martin, Jodi Picoult, and John Grisham. And this complaint says that OpenAI's ChatGPT models were trained on copyrighted works, and this constitutes the infringement of copyright, and those works belong to them, including their books. There are also other similar cases pending against OpenAI. Now, OpenAI denies all allegations, indeed, but we know that the ChatGPT models were trained on publicly available data on the internet. We know that there is a reasonable doubt that these works, some of those works, are copyrighted. Therefore, OpenAI might infringe copyright and engaged in the unauthorized use of copyrighted materials. Now, whether this type of practice is against the US law will be decided in a due course by the US courts. On the other hand, the EU AI Act allows web and data mining, and you can also mine copyrighted works, and you will be on the side of the law, so you won't be infringing anyone's rights. But if you scrape the data of a copyright holder who places a notice that is an opt-out notice saying that no, you should not scrape the data, then you will be an infringer. At the beginning of 2025, the emergence of DeepSeek, a new Chinese AI company, shocked the US stock market because it released the models, the new large language models that actually match and surpass the advanced ChatGPT versions. The latest model of DeepSeek, called R1, is released as an open source model. So all the information about it, about its source code, parameters, and training material is released, which allows the developers to build up same type of models or release the new models, which are advanced and even better. So they can build up on this R1 version. DeepSeek has also published the information about its training data, but the problem is that this includes only the information on specific data training techniques, and there is no information about the actual sources that DeepSeek used to train its data. So what type of data mining technique did the DeepSeek use to train its models? Now this is not disclosed to us. We don't know. It may be a new technique labeled as distillation. Now we know that the large language models such as OpenAI ChatGPT are trained with a large amount of data. So instead of doing data scraping from scratch, what the developer does is that developer takes the already existing model. It tries to distill as much output as possible. So it asks questions and gives prompts to this particular model, and this model then gives the output, and this output then is accumulated and used to train another new model. Okay, in that way you save the money, in that way you save all the resources, and it's a very convenient technique. Because it gives the competitive edge to the newcomers, new AI models, the already established AI companies are hostile toward this technique. Interestingly, OpenAI's terms of use directly prohibits using OpenAI's output to develop models that compete with OpenAI. In the last year, actually, Microsoft and OpenAI blocked several accounts, and they think that these accounts practice distillation, and also they believe that these accounts are associated with DeepSeek, which probably benefited by violating the terms of use of OpenAI. So the question is that it? Can't you make DeepSeek responsible by the force of law? That was a question, and the mainstream media came out with the concept of IP theft. They say that this concept was offered them by the sources affiliated with OpenAI. So if this type of thinking goes right, OpenAI would become a plaintiff and go to the court and claim copyright infringement by DeepSeek. Yet the situation is not like that. OpenAI's official position is that it is not going to sue DeepSeek. And what's more, Sam Altman considers releasing some of the versions, some of ChatGPT versions as open source, which will make more information available to us. Those developments raise certain legal issues. For example, whether AI output can be copyrightable and whether distillation is a legally compliant practice. There is a new report issued by the US Copyright Office which states that the copyright protection requires human authorship and other types of works won't be protected. It also invokes the reasoning developed by the US Supreme Court, which says that the human author is a person who translates the idea into a fixed, tangible expression. The report also tells us about the Ninth Circuit Court, which examined the cases of non-human authorship. One case was about non-human spiritual beings who wrote the text. Another one was about the photo captured by the monkey. And in both cases, the court determined that non-human authorship does not merit copyright protection. As regards the copyright protection of the purely AI-generated work, the report gives us the 2023 case of the US District Court for the District of Columbia, and the claimant is a man who appealed the decision of the US Copyright Office, and the US Copyright Office refused to register an image created autonomously by an algorithm running on a machine. And the court said that purely AI generated works don't merit copyright protection, and also this is the case because the person who asked for the registration of that work himself admitted that he did not play any role in the image creation, and it was purely created by the algorithm. So when is the AI generated output copyrightable? This happens when the human participation in the creation process is decisive, when the work expresses human creativity, and human exerts sufficient control over AI. So AI is not independent. The report also examines a case when a user enters the prompt into the AI model, and then AI generates the content. And the report says that this type of content is not also copyrightable. The case is that AI is a black box, and you can't accurately predict what will be the result of the prompt. And also the problem is that if you enter identical prompts, there will be multiple variation of answers. So it's difficult to control the answer of the model. Therefore, and in that case, there is no copyright protection. So there was a time when ChatGPT was a new fruit, and I decided to create an image according to my own design. I asked GPT to create an image with specific lines, shapes, and colors, and the instructions were really detailed. And DALL-E, the image creator of OpenAI, created the image for me, which did not match what I wanted to. Actually, it was more of a compilation of different images rather than one that I wanted. No matter how hard I tried, the result was the same. It was not according to my detailed instructions, and unfortunately the pattern remains the same today. When we need to determine the copyrightability of the AI work, what we do is that we assess the human participation. If human participation is decisive, then it is copyrightable. If it's not, if AI plays more decisive role, more important part, then the work is not copyrightable. Okay, so AI work will be copyrightable if AI plays a role of an accessory or a tool, and the example of this type of tool or accessory is a photo camera. With photo camera, the human takes a picture that is a expression of the art, okay, and it's possible to do so because the camera can be adjusted and directed in such a way that that the desired expression is provided. For example, the photographer, when using photo camera, adjusts the camera settings, selects the scenery, view, object, as well as angle, and in that way captures a photo that is a creative work. So if OpenAI decides to sue DeepSeek and say that its distillation practices, possible distillation practices, violate copyright, OpenAI's copyright, then the US law won't be on the side of OpenAI for sure. So it will require some type of extra legislation to make AI output copyrightable. Otherwise, there is no defense under the US law for OpenAI. It is also known that there are multiple cases against OpenAI for copyright infringement. And if the US court decides copyright infringement by OpenAI, is it possible for those plaintiffs to also sue DeepSeek for the secondary copyright infringement, because the DeepSeek probably distilled the output? Actually, under the US law, it's possible to make a party responsible for the contributory infringement. The contributory infringement happens when the party knew about the infringement yet facilitated it. And I don't believe that in that case we have contributory infringement, but I believe that if there is a copyright infringement determined by the US courts, probably the claimants, the plaintiffs, have a ground to also sue DeepSeek for the secondary infringement. We have already learned that under the US law, AI output is not copyrightable. What about the EU law? So the EU law clearly states that web and data mining is possible unless there is an opt-out, that is to say a reservation of IP rights. In that case, authorization is required. We also are aware that OpenAI expressly prohibits using its output to develop the models that compete with OpenAI. And if we say that text and data mining is also the same as output distillation, if we equate distillation with text and data mining, we will find out that DeepSeek actually went against the opt-out of OpenAI, which set a restriction, and yet by distillation, the DeepSeek actually used OpenAI's output, and OpenAI clearly said that no, you can't use my output. That was the case. So will be DeepSeek responsible under the EU law? Unfortunately for OpenAI, under the EU law, text and data mining exception will only apply if the person who sets the opt-out has a copyright. And under the EU law, actually countries agree that the copyrightability applies only to the work of human authorship. Purely AI-generated works don't merit copyright protection, and this was actually confirmed by the court of the Czech Republic. Also, it is needless to say that OpenAI is an US company and it will be under the EU jurisdiction only in a limited number of cases. As of today, except for the copyright defense, I can't find any legal provision that would help OpenAI to protect its output from distillation, and therefore it is a problem for OpenAI to go to the court and sue DeepSeek because the claim that OpenAI might have will be easily defeated in court. Now let us take a look at the issue from a different angle. I checked the corporate structure of OpenAI and found that OpenAI is the amalgam of various LLCs. They are all registered in Delaware and they have their principal place of business in San Francisco, California. I also found out that the code of Delaware, its section 2103, says the following, that it is unlawful to monopolize the trade or commerce of the state. Also, there is section 17,200 of the California Business and Professions Code, which says that unfair business act or practice qualifies as unfair competition. So, as we know, OpenAI clearly states in its terms of use that it prohibits using its output to develop the competing models. And actually, all states, all 2 states to which OpenAI is clearly related, prohibit anti-competitive practices. So then the question is it fair to prohibit using output that even doesn't merit copyright protection for distillation and development of other models? I think that it can be counted as anti-competitive. So I believe that the emergence of DeepSeek is good for competition and in general for innovation. Also, it should be noted that the emergence of DeepSeek caused a huge disruption. It disrupted OpenAI's dominance and also provided some interesting solutions to pressing problems, such as, for example, the ways to save computing power. So now OpenAI is making its models to work with less computing power, and what's more, it wants to make more information available to us about its models.